He should be back in the back.
Okay, for the purpose of the record, this is November 19th, 2021 bond hearing calendar. This is case of State of Georgia versus Willie Barnes. He's charged in warrant number 2021 CW 55433 with committing the offense of homicide by vehicle first degree, and in warrant 2021 CW 55434 with committing the offense of hit and run by accident. My understanding is that there are no witnesses that are going to be presented here today. It's just going to be argument.
That's correct, Your Honor.
Okay, so I believe, Mr. Florio, you have the right to go first and last. This is
Thank
your
you, Your Honor.
motion.
Thank you very much, Your Honor. Your Honor, by way of a brief factual understanding of the allegations in this case, on or about October the 6th of 2021 at 8:25 p.m., there was an accident. This accident occurred over on Mount Zion Boulevard, over by the old Joe's Crab Shack and Barnes & Noble and AMC movie theater. I believe had we had the preliminary hearing yesterday, I believe the evidence would have shown that the victim in this case, a young man, he would have been coming from the Home Depot side of Mount Zion Boulevard, crossing Mount Zion, going towards the Joe's Crab Shack AMC theater side of Mount Zion Boulevard. I think the evidence would have shown, Your Honor, that he crossed the first lanes of travel. I think that would be either north or east. I'm terrible, but going towards Morrow. He would have crossed those lanes of travel. He would have entered into the center median, Your Honor, and then he would have entered into the other lanes of travel. I believe the evidence would have shown, Your Honor, that the young man entered into the lanes of travel not at a crosswalk and not at an intersection, but at a location where there would have been a MARTA bus stop. And so I think what the evidence would have shown is that the young man victim entered into the roadway at 8:25 at night. And at that time, the allegation would be that Mr. Barnes struck him. I don't believe, based upon the investigation that we've done over the last week, I don't believe, Your Honor, that there would be any allegation that Mr. Barnes was speeding, that he was operating his vehicle in a reckless manner. There were no issues with Mr. Barnes's insurance, no issues with registration, no issues with license. Mr. Barnes has no warrants. He is not on probation. He is not on parole. No allegation that Mr. Barnes was DUI, no allegation that Mr. Barnes was harboring a fugitive, or that Mr. Barnes had any contraband in his automobile. I believe the allegation further would have been that the young man was unfortunately struck by multiple vehicles. We don't know if the allegation from Morrow Police is that Mr. Barnes was the first vehicle or just one of the vehicles, but by way of investigation and media reports from the victim's family has indicated that the young man was struck by multiple vehicles. The young man passed. We believe that there were witnesses to the incident. We believe that witnesses to the incident immediately attempted to contact 911 and did immediately attempt to render aid to the victim, but unfortunately he passed. I think the evidence would have been, Your Honor, that Mr. Barnes continued down Mount Zion Boulevard, made a U-turn, came back, and then continued to his home. And that would have been based off of block video camera that Morrow Police have since obtained. In the month since this occurred, there's not any proof that Mr. Barnes has attempted to flee the jurisdiction of the court, that he's attempted to leave the state, that he's attempted to contact witnesses, that he's attempted to destroy evidence. Essentially what happened is, by way of investigation, Morrow Police, by viewing flock video camera and speaking with an anonymous caller, went to Mr. Barnes's home. Mr. Barnes's vehicle was parked in the driveway. And Morrow Police were able to view Mr. Barnes's vehicle. They believe that there was damage to his vehicle. They received a search warrant for the vehicle. And within a few days, a matter of days, a warrant was issued for Mr. Barnes's arrest. Your Honor, when this occurred, Mr. Barnes contacted me immediately. We obtained the warrant, met in my office, reviewed the warrant. I was retained, and then Mr. Barnes immediately surrendered himself to the Clayton County Sheriff's Office. He drove himself to the jail last Wednesday and surrendered. So within a matter of a day, maybe 2 days of learning that there was a warrant for his arrest, and that law enforcement were attempting to arrest him, he did surrender himself voluntarily to the jail. Your Honor, Mr. Barnes is 42 years old. He was born in Griffin, Georgia, but grew up here in Clayton County. He attended Forest Park High School, graduated from Forest Park, and then began working. And that's essentially what his life has looked like. He has 4 children, and 2 of them live with him. He has a 27-year-old daughter and a 25-year-old son. They live in the home with him, along with his 7-year-old grandson. He also has a wife who he's been with since he was 13 years old, Judge. And so she is the one and only love of his life. They've been together since they were teenagers, and have been married for several years. They have 4 children, as I indicated, a 27-year-old, a 25-year-old, a 23-year-old, and there's a 16-year-old as well. Your Honor, he has significant health issues. A year ago, so in 2010, at the age of 32, Mr. Barnes suffered a stroke and was diagnosed as having been in congestive heart failure. And he struggled with diabetes his entire life. Over the last 10 years, he struggled with serious health issues as a result of the heart failure and the stroke. And in 2020, November of last year, right at about a year now, he was the recipient of a heart and kidney transplant. He is deemed 100% disabled. He has regular visits with his doctors, and these visits are usually run about every 2 to 3 weeks. While he's been in custody, he's missed one of those visits. And this is something that he and I talked about prior to his surrendering. He understood that his incarceration was going to cause him to not be able to see his doctor, and not be able to get the medical care that he is accustomed to getting and should be getting. But he obviously made the choice that he had to do the right thing. He had to surrender. And so we surrendered, understanding the peril to our own health that we faced. His family's resources, Your Honor, are very limited. His wife is a chef at a Thai restaurant. But he is disabled. He has family support, and so I don't want to give the court the impression he doesn't have family support, but he does. But I've met with his brother, I've met with his sister-in-law. His family's resources, Your Honor, candidly, are very limited. When I review the warrants, I think one of the most important things, and I know the court's familiar with the vehicular homicide and first-degree statute, but when you review the warrant, the first words are, said accused did without malice cause the death of another person. And I think it's important in a case like this. Certainly, it is a tragedy that a young man lost his life, and my heart goes out for the victim's family, and Mr. Barnes's heart goes out for the victim's family. I've watched him weep as he and I have discussed this case, not for himself and not for his family, but for the young man who lost his life. But the allegation is without malice. He did not know this young man. There was no prior relationship between them, no animus between them. This was a terrible accident, and we understand that a young man has lost his life, but at the end of the day, it was an accident. And if you believe everything that the detective says, and you believe that Mr. Barnes, was there and did flee the scene, his having left the scene did not affect the ultimate outcome. Whether Mr. Barnes had stopped his automobile or whether Mr. Barnes left, I believe the evidence would show that the young man still would have passed. And we understand the serious nature of the charges, Your Honor. and we respect that. But I also want to try to get my client a bond that he has a realistic shot of making, because he himself does have significant issues, as we've indicated. We would ask that the court set bond an amount of $25,000. I think it respects the allegations in this case, and respects the victim and his family. I think it also provides my client an opportunity to post bond. And in full candor, I literally just asked him in the breakout room, do you think you can make a $25,000 bond?
I'm gonna mute the jail.
Thank you, Your Honor.
Okay.
And I asked my client, I said, if the Honorable Judge Gardner were to set bond in the amount of $25,000 this morning, I said, is your family prepared to make that? And honestly, he told me no. He said they're not. And so it's not a number. He's not sitting around with a bunch of money where he's ready to bond out this evening. But I think it's at least the number that his family has a realistic shot of making. And so I'm not asking for that bond because I'm trying to save him money. I'm asking for the bond because I think that if not today, at least in the near future, it's a bond that he and his family have a chance of making. But I also want to respect the fact that there's a young man that's lost his life. And I don't want to disrespect that by asking for a bond that's just so low that it doesn't take into account that loss of life. Your Honor, I don't believe that there's any evidence before the court that Mr. Barnes will flee the jurisdiction of the court. Since this accident in October, he's remained here in the county. He lives I'm sorry, Judge, he lives in Stockbridge. So he lives just over the county line in Henry County. I apologize. But he has family throughout Clayton County, Spalding County, and Henry County. There's not any proof that he's attempted to leave the jurisdiction of the court in the last month. No proof that he would leave the jurisdiction of the court if granted bond. No proof that during the last month that Mr. Barnes has attempted to reach out to any witness to this case, that he's attempted to influence, intimidate any witness in this case. No evidence that he's tried to destroy evidence or that he would destroy evidence. His criminal history is minimal with misdemeanor convictions. I believe, and I'm sure Ms. Freeman will correct me if I'm wrong, but I believe this would be his first felony arrest in life. I don't believe he's a convicted felon, but I don't have the benefit of his criminal history. I know he had I believe a forgery charge. That may be his only felony, but that would have been, I think, over 20 years ago. And so for those reasons, Your Honor, we would ask that bond be set in the amount of $25,000. Thank you, sir.
Okay, thank you, Ms. Freeman.
Thank you, Judge. Attorney Florio, gave a good rendition of the facts. I will say this young man was 22 years old. I don't have any information regarding there were multiple vehicles that struck the young man. I don't have a full report at this time, but I do have that the video footage that was reviewed showed the vehicle that Mr. Barnes was driving. After this young man was struck by the vehicle, he did a U-turn and drove past the scene. Police did find a Chevrolet emblem on the ground. And when they executed the search warrant, Mr. Barnes's home and looked at his vehicle, in addition to the damage to it, they also noticed that it was missing a Chevrolet emblem. But again, I don't have any information that multiple vehicles struck the young man and which vehicle caused the death, but we do have information that it was that Mr. Barnes did strike this young man and kept going. Judge, I have to say that, based on our communication with the family, they are opposed to a bond. They lost someone that was, dear and special to them, who wasn't doing anything but crossing the road at Mount Zion. Mr. Barnes does have a little bit of history. He had a first offender on a BGCSA back in 2007, but he was able to complete first offender. In 2009, he had a DUI. 2010 is a forgery. In the first degree, I think Mr. Florio alluded to that. 2013, he had another DUI. And in 2013, he got stopped for driving with a suspended license. And from those misdemeanors, I will say that he does have several probation violations regarding those charges, Judge. I understand what Attorney Florio has said about the medical history, and I do know, with him having a transplant and different medication, I guess, and treatment that he will need. However, the family of this young man is opposed to a bond. And at this point, Mr. Barnes is not entitled to a bond. If the court were inclined to grant a bond, we certainly would ask for more than $25,000. We don't think that $25,000 is appropriate when this young man has lost his life. And so if the court is inclined to grant a bond, we would ask for a minimum of $50,000 on the homicide by vehicle and a $25,000 on a hit and run. Thank you, Your Honor.
Thank you. So let me ask this question. Between the time of the incident and the time when the police first encountered Mr. Barnes at home, do we know the length of that time?
It was about a month, Your Honor. I believe the incident occurred on October 6th of 21, and the warrant was issued November the 5th of 21. The warrant was just issued 2 weeks ago today. So there was a 30-day period between the accident and the warrant. I believe the warrant was executed for his truck about less than a week before this warrant was issued. So maybe 3 weeks after the accident, the Morrow police obtained a search warrant for his automobile.
Okay.
So about 3 weeks after the accident, I believe.
Okay. Is there anything else, Mr. Florio?
Judge, I understand Ms. Freeman's position, but the purpose of bond is essentially to assure that he doesn't leave the jurisdiction of the court, that he returns for future court dates. And practically speaking, I don't know the difference between 25 that I'm asking for and 75 that Ms. Freeman's asking for. I don't think that one guarantees that he's gonna return to court and the other one doesn't. The only difference is how much money is free at last or anytime bail bond's going to get from his family. But whether it's a $25,000 bond or $75,000 bond, the same guarantees still exist that he's not going to leave the jurisdiction of the court, that he's going to return to court. And I understand her position. I understand that the young man passed. But the facts of the case, I mean, there's going to be an allegation that at 8:26 p.m., the young man walked into oncoming traffic, not at a crosswalk and not at an intersection. And unfortunately, this terrible incident occurred. And so I'd ask the court to take into consideration the facts of the case as well. And there's no allegation we left the roadway or anything of that. The allegation is that the young man crossed from the center median into oncoming traffic, trying to get to a bus stop on the side of Mount Zion Road. And unfortunately, while in the lane of traffic, was struck by an automobile, not at a crosswalk and not in an intersection. And unfortunately, we find ourselves in this position. So we would ask the court to grant the $25,000 bond, Your Honor. Thank you.
Okay, well, I'm inclined to set bond. The thing that bothers me as it relates to this case is that he failed to stop and at least attempt to render aid or something to that effect. And the length of time between the incident and the police encountering Mr. Barnes, there may be a reason for that. I mean, not a reason, but there may be issues as it relates to evidence that could have been collected at the scene not being collected, or things that possibly could have either helped Mr. Barnes or hurt Mr. Barnes. So I'm going to grant a $10,000 bond on the hit and run and a $25,000 bond on the homicide by vehicle.
Thank you very
Judge, I
much.
will give that order to your honor. And can we also have in the bond order, and I don't think this is an issue, but just to make sure to stay away from the family of Tyree Johnson. That was the young man that was killed. Like I said, I don't
Yes.
think it'll be an issue, but just to have it in there.
Yes, stay away from, his name was Tyreek Johnson.
Tyree, Tyree Johnson.
Okay. Tyree Johnson. Stay away from Tyree Johnson. I understand that he has to have visits to the doctor. You said he's 100% disabled. Is there any reason that he can't abide by limiting his driving to his doctor visits? Let's see, doctor visits, visits to church, and any like pharmacy related or medical related driving.
If we could also include any legal, like to come to see me,
Yes.
his lawyer. Yes, sir.
Yes.
Yes, sir. I don't think, yes, sir, Judge, that's fine.
Well,
Certainly any,
Well, I
Go
was
ahead,
going to
Ms.
say the bond order does have, and this is just a line for curfew, but I can make sure that his driving is limited, but it lists school, church, work, doctor, or attorney visits. If that language,
That's-
that would work.
Yes,
is that
yes.
okay with you, Attorney Florio?
Yes, ma'am,
Awesome.
that's perfect. Thank you, Ms.
Okay.
Freeman. That's
And
a
so
great
we'll-
idea.
Yeah.
Okay. Okay, is there anything else for this case?
No, Your
That's
Honor,
right, Your
if
Honor.
you can give me a couple minutes, I'll get this order to you for your signature.
Yeah, take your time. I have no place to go.
All right, just give me 1 second and then I'll be back on camera.
Okay,
All right, thank you.
Thank you, Your Honor.
you're
And
welcome.
that's, Your Honor,
Mr.
as for
Barnes.
me,
Yes, sir.
I apologize. I didn't mean to interrupt you.
No, I was going to say Mr. Barnes can be sent back.
And Your Honor, if I could talk to my client, I think there's something that he needs to consider when we
Okay.
make a decision whether to agree with the state or go forward.
Okay, I'm going to place Mr. Fry in the breakout room with the jail. Okay, I just placed you in. The jail is already there, so they should be able to click on the link.
Huh?
He's been in there too long. He forgot to say yes, sir, yes, ma'am.
Oh shit, me and him are okay.
We're still live on YouTube.